Hi, Sean Gilliam here. Welcome to another episode of my podcast, Real Estate on the Front Range. This is another video in my series of how to buy a home where I give information and educate you as prospective home buyers in all the various steps involved in buying a home here in Colorado. In this video, I'm going to be covering the exclusive right to buy contract. This is a document prepared at the state level by the Division of Real Estate that when we review it and come to terms and sign it, it makes me exclusively your real estate agent. And that means you're not working with anybody else. You're working with me. I'm here to help you find the home that's perfect for you and get you to the closing table so you can get those keys and get into your house. So stay tuned as we get into the details of what this contract covers and what it means for you as a home buyer. Okay, so here's the actual contract. This is what it looks like. We'll go ahead and start from the top. I'm going to highlight some important aspects of this document. A lot of it is boilerplate language, and you can read through that yourself. It's pretty straightforward. But some of the things where there's some negotiation to be had or some important points to highlight, I'm going to point those out here in this video. As you can see here at the top, this is the latest version as of August 2024, and it's been approved by the Colorado Real Estate Commission. So that gives you confidence that attorneys at the state level have put this document together to protect you as a consumer out there that wants to purchase a home. The next couple of sentences are in bold print, and these are also very important. This is a binding contract. This form has important legal consequences, and the parties should consult legal and tax or other counsel before signing. So if this is something that you want to do, I should add that in Colorado, you don't have to have a real estate attorney involved. If you're from the Midwest or the East Coast or other places, it is part of the contract or part of the process in purchasing a home that you have to have an attorney. Not so here in Colorado. But if you do want to consult with an attorney or a tax professional, make sure you take the time to do that before we get out there and you find the home you want to buy and want to write an offer. Because in your counsel that you get from these professionals, you may or may not want to purchase that home because of the tax implications or legal implications or what have you. So make sure that you let me know if that's something you want to do so you have time to get that done. Then it goes on to say compensation charged by brokerage firms is not set by law and is fully negotiable. So straightforward, compensation to me is fully negotiable, and that's a discussion we can have when we get to Section 7 of this contract. And then it goes on to say different brokerage relationships are available, which include buyer agency, seller agency, or transaction brokerage. And this is something that we're going to cover later on in this contract that talks about the different roles that I can serve you in. If you're working with me or we've already met, I would have given you the brokerage disclosure to buyer that defines these terms as well. I also have a video on that, so you can take a look at that. But those are the different roles in which I can serve. Now let's go ahead and look at the main parts or sections of the contract. As you can see here right at the top under exclusive right to buy listing contract, you have two boxes to check. And the first box is buyer agency. The other one is transaction brokerage. If you're not familiar with these terms, in brief, buyer agency is where I am your fiduciary. I'm in your corner. I'm trying to get you the best deal possible. I have your best interest in mind. As a transaction broker, I am more of a facilitator or just a messenger. So it's a different level of service. We'll cover this in Section 5 and 6 of this contract. But whatever one you select, whatever one you prefer, that's the box that we'll check here. And that will determine my role and my responsibilities, as we'll see in the remainder of this contract. Then we get into Section 1 that defines this agreement. Buyer and brokerage firm enter into this exclusive, irrevocable contract, also known as a buyer listing contract, and agree to its provisions. Broker, which would be me, on behalf of brokerage firm, agrees to provide brokerage services to buyer. Brokerage firm will receive compensation as set forth in this buyer listing contract. So that's how the agreement is defined. Then we get to Section 2, and that talks about the brokerage firm that I work for. I always check the box for multiple listing or multiple person firm because there's multiple people that work for my brokerage. And then we get down to the defined terms. That's where your name will be, and then the brokerage that I work for, location real estate, and my name. And then the property speaks to the property means real estate, which substantially meets the following requirements or is acceptable to buyer. And in this blank, we would put what kind of property you're looking for. We can be very vague or very specific depending on what your needs are. So that can range from a home in northern Colorado down to a specific property address or different requirements. And that's a discussion that we would have. 3.5 talks about whether or not you're purchasing or leasing a property and defines what those are. Then we get down to 3.6 that talks about the listing period. That is the time frame during which this contract is active and binding. We have to have a begin date and an end date, and that end date or that period of time cannot exceed 1 year. And so we have to have it for less than that. A lot of times I'll do 6 months. It really depends on what your needs are and what your time frame is. If we run out of time, we can always do an amendment that would extend that listing period. And so that is an option as well. So, but this defines that period of time during which this contract is active and binding. 3.7 and 3.8 are pretty straightforward. I'll let you take a look at those. And then we get down to section 4 where we talk about the brokerage relationship. And this references those 2 boxes at the top of this contract that I referenced earlier. If the buyer agency box at the top of page 1 is checked, broker represents buyer as buyer's limited agent. And you'll see how that's defined in section 6 of this contract. If the transaction brokerage box at the top of page 1 is checked, broker acts as a transaction broker. And those responsibilities or that level of service is defined in section 5 of this contract, as we'll see shortly. 4.2 is a good definition of how I'm to interact with you if the seller is represented by another broker within my office. So it goes on to say, when the seller and buyer in a transaction are working with different brokers within the brokerage firm, those brokers continue to conduct themselves consistent with the brokerage relationships they have established. So if you have me working as your agent, I continue to work as your agent, even though a colleague of mine is representing the seller. I think what's more important to point out here too is that I have that professional responsibility to protect your interest and not share things that might be overheard by that broker working with the seller. This protects you and protects your ability to negotiate in the transaction. So that's something that I need to be aware of and make sure that I protect your interests in my interactions with my colleagues in the office. It goes on to say that buyer acknowledges that brokerage firm is allowed to offer and pay compensation to brokers within the brokerage firm working with the seller. So that just means I'm allowed to get paid if I'm representing you and you're purchasing a home that is represented by a broker working within the same office. So 4.2 talks about if I'm working with you and somebody in my office is working with the seller. 4.3 talks about a different scenario. If I'm working with you and I come across a seller that has no representation, and so therefore I represent both you and them, Section 4.3 talks about the different roles and limitations involved in that relationship. So I'll go ahead and read this for you. It says, if the seller and buyer are both working with the same broker, me, broker will function as, and 4.3.1 gives the first option, buyer's agent. So if that buyer agency box at the top of page 1 is checked, then the parties agree that the following applies. Buyer agency unless brokerage relationship with both. I'll read this paragraph because it helps to define it. Broker represents buyer as buyer's agent, so I'm working exclusively with you as your agent, and therefore I must treat the seller as a customer. A customer is a party to a transaction with whom broker has no brokerage relationship. So I owe them no uniform duties. Our brokerage duties is defined in Section 5 of this contract, and I'm certainly not their agent. So I don't have any responsibility to them. But it goes on to say the broker must disclose to such customer the broker's relationship with the buyer. So I have to tell them if I'm working with you as an agent or as a transaction broker. However, so here's an exception. However, if broker delivers to buyer a written change of status that broker has a brokerage relationship with the seller, then broker is working with both the buyer and seller as a transaction broker. So if I have a brokerage relationship with the seller also, and you agree to it in this transaction, then the level of service I can provide if I'm working with both you and the seller is that of a transaction broker. Meaning I can't be your agent any longer. We have to reduce the level of service to that of a transaction broker. So I'm just your messenger and a facilitator. And likewise with the seller, I'm just a messenger and a facilitator. I owe no duties of advocacy, fiduciary responsibilities, any of those kinds of things. I cannot provide that level of service to either you or the seller. So it's a difficult potentially difficult scenario to maintain those boundaries. But as a professional, I'm responsible for doing that. Again, this is only if you agree to that. It goes on to say, if the box in 4.3.1.2, buyer agency only, is checked, then buyer agency only applies instead. So we can have this discussion if we're working or putting together this contract. You can say, I want to check the box for buyer agency only. I want you to fully represent me as my advocate and my fiduciary. I don't want to change that level of service. If that's your interest, then we can check that box in 4.3.1.2. And then moving forward with any seller, either they have representation and I'm interacting with their agent that's representing them, or they're a customer and I owe them no brokerage relationship responsibilities at all. And then we get down to 4.3.2, and it says, if the transaction brokerage box at the top of page 1 is checked, or in the event neither box is checked, broker must work with buyer as a transaction broker. So by default, my relationship with you is that of a transaction broker. A transaction broker must perform the duties described in Section 5 and facilitate purchase transactions without being an advocate or an agent for either party. If the seller and buyer are working with the same broker, broker must continue to function as a transaction broker. So those are the roles in which I can serve in, and the various scenarios that give me some opportunities and limitations to how I can represent you and a potential seller that you might want to work with. Section 5 talks about brokerage duties. These are the uniform duties that I owe to you if I'm serving you as a transaction broker. Similarly, they're also the duties I must give to you if I'm your agent. So if I'm working with you as a transaction broker, I owe you Section 5 duties as delineated here. If I'm working with you as an agent specifically, then I owe you 5 and Section 6 responsibilities. And I'll get to Section 6 here shortly. But it goes on to say here, broker acting on behalf of brokerage firm as either a transaction broker or a buyer's agent must perform the following uniform duties when working with buyer. It states, broker must exercise reasonable skill and care for buyer, including but not limited to the following. I need to perform the terms of any written or oral agreement with you as the buyer. Pretty straightforward. I must present all offers to and from you in a timely manner, regardless of whether you are already a party to a contract for the purchase or lease of a property. 5.1.3 points out that I must disclose to you any adverse material facts actually known by me. So if we come across a property and I know that there's something wrong with that property, any adverse material facts, I have a responsibility to disclose that information to you. 5.1.4 talks about advising you regarding the transaction and advising you to obtain expert advice as to material matters about which I might know something, but the specifics of which are beyond my expertise. So I might know a little bit about radon, I might know a little bit about structural matters and other things like that, but I'm going to advise you to contact a professional for extra advice and get an expert's opinion so that you're fully informed about a particular matter or issue related to a house. 5.1.5, it talks about accounting in a timely manner for all money and property received. And so I'm going to be quick about responding in this day of an age of technology with cell phones and all that. I have all sorts of information at my fingertips. I know when I get emails or texts or what have you, and I'm quick about getting that information to you. The Division of Real Estate would set a standard of at least within 24 hours, but typically you'll get that much sooner from me as far as information that I receive from other parties. And then I have to keep you fully informed regarding the transaction. That goes along with the section I just mentioned, keeping you apprised of what's going on. And we'll have multiple conversations throughout any given week if we're in a transaction, so that I like to keep you informed as to what's going on, what next steps are, what deadlines are coming up, all those kinds of things, so that you're aware and have sufficient enough time to make decisions if that's required. 5.2 is a little bit different. These are the things that I must not disclose regarding you without your informed consent. And so I must not disclose without your consent that you are willing to pay more than the purchase or lease price offered for the property. So when I'm negotiating on your behalf, unless you tell me to do so, I'm not going to let a seller know that you're willing to pay more than the actual purchase price. I'm also not allowed to disclose what motivating factors you have. A seller might ask, or their agent might ask me questions about you. Why do you like this house? Or why do you want to buy this house? Or why are you moving to this neighborhood? Whatever the case may be, unless you give me permission, I'm not allowed to share what your motivating factors are. And then the next one states that the buyer will agree to financing terms other than those offered. So if you have agreed to use a conventional loan or a VA loan or what have you, I am not allowed to disclose that you're able to finance with another type of loan unless you give me permission to do so. And then 5.2.4 talks about any material information about buyer unless disclosure is required by law or failure to disclose such information would constitute fraud or dishonest dealing. So I'm not allowed to share any information about you unless I'm required by law to do so. And you'll see later on, if you might not be able to afford the home or you have very limited financing, some of those things would fall into the category of adverse material facts. And I would have to share that with a prospective seller. 5.3 goes on to say that the buyer consents to broker's disclosure of buyer's confidential information to the supervising broker or designee for the purpose of proper supervision, provided such supervising broker or designee does not further disclose such information without consent of buyer or use such information to the detriment of buyer. So signing this contract gives me permission to talk to my managing broker, my supervising broker, in case I need some advice or a second opinion on how to move forward with a transaction or other obstacles that we might come across. It helps you and it helps us to have all the best information at our fingertips to help you move forward. 5.4 is a disclosure that allows me to work with other buyers that may be interested in the same property that you're interested in. I will disclose that to you and let you know, hey, I'm showing this property to other buyers, or I have a buyer that wants to write an offer on this property. And so that way you're aware of that. And then I also let them know that I'm working with a buyer that may also be interested in the same property. I don't go beyond that. I don't share information about you with them, and I don't share information about them with you so as not to hurt that professional relationship or bring any detriment to your ability to buy the home. But it's important for you to know that I do have the ability to show other buyers the same home that you're interested in and potentially write offers on those properties. 5.5 talks about how I'm not obligated to seek other properties while you're already a party to a contract. So I'm not obligated to, but there may be scenarios, and I've had it happen, where a buyer that I'm working with is about to terminate on a contract because they found something about the property that they don't like, and they're allowed to do that. And so we terminate in a timely fashion to get their earnest money back. But in the process, we can renew their search and keep an eye out for other properties that might work for them. So it's not obligated, or I'm not obligated to find other properties, but if we have a discussion and it's a good idea to do so, we can do that. 5.6 points out that I have no duty to conduct an independent inspection of the property for the benefit of you as the buyer, and I have no duty to independently verify the accuracy or completeness of statements made by a seller or independent inspectors. Broker has no duty to conduct an independent investigation of buyer's financial condition or to verify the accuracy or completeness of any statement made by me, you as the buyer. And so I take things at face value. I trust that an inspector or a seller is being fully honest. I am not obligated to go out and verify that information. Similarly, I'm not obligated to verify whether or not you're telling me the truth about your ability to finance a home or whatever the case may be. So I take everybody at their word and hope they're all being honest. In fact, these contracts are written with the intent of all parties involved moving forward in good faith, fully honest, with integrity, and not trying to hide information or to be deceitful. 5.7 talks about how I must disclose to any prospective seller all adverse material facts actually known by broker, including but not limited to adverse material facts concerning the buyer's financial ability to perform the terms of the transaction and whether the buyer intends to occupy the property as a principal residence. So I must disclose those adverse material facts to a prospective seller. 5.8 is last on the list of uniform duties that I owe to you as a transaction broker or as an agent. It states that buyer understands that buyer is not liable for broker's acts or omissions that have not been approved, directed, or ratified by you as the buyer. What this is talking about, if I go out and say or do something that you did not give me permission to do and it has detriment to you, that is not your responsibility. You are not liable. That's all on me. Now, I will tell you, as a professional, I know contract law, I know my responsibility, I'm ethical, and so I'm not going to do anything that would bring detriment to you. Also, I'm not going to do something that you did not ask me to do. So we're going to have throughout my professional relationship with you and during a transaction, we're going to have a meeting in the minds and come to an agreement about the next step forward. And then I'm going to go ahead and carry out exactly what we agreed upon that I would do. And so this, again, protects you that you are not liable if I do something unprofessionally or unethically that you didn't give me approval for. Now we get into section 6. So by default, as your transaction broker, I owe you the uniform duties as depicted in section 5. But if I'm your agent, I owe you these additional duties of a buyer's agent. I should point out here that the term agent is used generically. It's my job title. In conversations, people just talk about me as a real estate agent. But when we get to a contract, an agent is a very specific legal term. And it's defined here in section 6. So I'll go ahead and read it to you. It says, if the buyer agency box at the top of page 1 is checked, broker is buyer's agent with the following additional duties on top of what's already been stated in section 5. 6.1 states that I have to promote the interests of you as the buyer with the utmost good faith, loyalty, and fidelity. 6.2 states I need to seek a price and terms that are acceptable to you as the buyer. This is where I'm your fiduciary. And then I have to counsel you as to any material benefits or risks of a transaction that are actually known by you or me as the broker. So I'm giving you advice. I'm your advocate. I'm trying to give you the best information so that you can make the best decision moving forward. So it goes above and beyond the uniform duties described in section 5 and makes me specifically your agent. These are the duties that I owe to you as your agent officially. Section 7 talks about how I get paid. And typically the way it works legally is my brokerage firm gets paid and thus I get paid through them. So it goes on to say, in consideration of the services to be performed by brokerage firm will be paid as set forth in this section with no discount or allowance for any efforts made by buyer or any other person. Unless approved by buyer in writing, brokerage firm is not entitled to receive additional compensation, bonuses, and incentives paid by listing brokerage firm or seller. An example of how that might apply is if you're buying a new construction home and a builder is offering an incentive that if I get you under contract within the next 30 days or whatever, that they're going to provide some bonus amount. And so I would talk to you and say, hey, I know you want to buy this house. They're paying me this much commission and they're offering a bonus. Is that okay with you? And you'd say yes or no, and then we'd get that approved in writing between the two of us. So that's where that would apply. And then in 7.1, it talks about the brokerage firm's fee. So a success fee is the amount that I'll get paid at closing for my services to you. And that can be either a percentage. So as you can see in 7.1.1.1, it's a fee equal to X.X% or whatever the case may be of the purchase price or a flat dollar amount. And so that would be the agreed upon fee that I'm going to get for my services. And it's important that we have a specific amount here, as you'll see later when we read some of these other paragraphs pertaining to compensation. When we get down to 7.1.1.3, the success fee is earned by brokerage firm upon the purchase of property and is payable upon closing of the transaction. So that's when I get paid. If any transaction fails to close as a result of the seller's default with no fault or on the part of the buyer, the success fee will be waived. So if the seller does something that causes the contract to fail because they defaulted on the provisions of the contract, and understand default is a legal term, meaning they violated some provision or stipulation of the contract. And end result being that we don't get to the closing table, you don't get the house that you want, you don't have to pay me a fee for my services. However, if any transaction fails to close as a result of your default, in whole or in part, the success fee will not be waived. Such fee is payable upon buyer's default, but not later than the date that the closing of the transaction was to have occurred. Now, I do want to point out that if we're under contract on a property and you have a right to terminate during the inspection period because you found out that the roof is leaking and the seller doesn't want to pay for it, or some other condition that you just do not find acceptable in your sole subjective discretion as a contract reads, and you terminate, you get your earnest money back and we move on to look for other properties. That doesn't mean that you owe me a success fee every time you legitimately terminate a transaction. Because I've had it happen where buyers had to terminate for a good reason, and we moved on and looked for other properties. They were not obligated to pay me a success fee every time we went under contract. It's only if you're in default because you violated some provision of the contract. Then we scroll down here to 712. I don't do hourly fees. You would not want that for all the time I put into doing research or driving around, showing you homes, what have you. That would add up pretty quickly. I don't do retainer fees. That's similar to what attorneys typically do. Other compensation, if I were to provide some additional service that you asked me to, we would stipulate what that is and how much that would cost. And so we'd put that in 714. Brokerage firm's fee for leasing. I typically don't do leasing, but it's similar wording. Then we get to 7.3. Who will pay the brokerage firm success fee? And so this is where it's a little bit different now. Real estate is a little bit different moving forward since the whole NAR settlement. I won't get into the details of that, but they have some rules now. Prior to that, we had three options for how it would be paid, or three separate subsections here under 7.3. We have seller's brokerage firm or seller may pay, buyer is obligated to pay. The second one is buyer will pay. There used to be a third one that the buyer is not obligated to pay. They removed that because now the way they want to see the way things happen is that there's negotiations between parties, and but typically the expectation is that you would pay me and that the seller would pay their agent, and that's how we'd conduct ourselves. It's kind of how they do things in commercial transactions. However, sellers do have the option, if they want to pay me for my services and bringing you to the table and getting you to closing. And so it's a case-by-case basis now. It used to be stated clearly how much I would get paid by the seller in the MLS. They've removed all that. And so now we kind of go blind into each potential transaction, and I have to find out if the seller is even willing to pay me anything for my services. If they're not, then you would have to pay me for my services. Everything's negotiable. It's just the way we do things now. But I'll go ahead and read these two subsections here to give some clarity onto who will pay my brokerage firm success fee. So that first option, seller's brokerage firm or seller may pay, but the buyer is obligated to pay. So the broker is authorized by you as you sign this contract and instructed to request payment of brokerage firm success fee from one or both of the following, either the seller's brokerage firm or the seller. The buyer is obligated to pay any portion of the success fee which is not paid by the seller's brokerage firm or seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. So I'll scroll back up to here for 711, where it talks about the amount. So whatever percentage there is there, or of the purchase price, or some flat dollar amount, if the seller is paying me less than that, and I'm willing to accept that, if there's any difference or whatever the difference is, you're obligated to make up the difference. Now, everything's negotiable. I'll say that for when I'm actually working with you and we can come up to some agreed upon terms, but that's how the contract is written now for that specific information. And then I scrolled past it. We get here to 7.3.2. So either the seller is going to pay me or you are going to pay me. And that reads, buyer is obligated to pay the brokerage firm success fee. Brokerage firm is not entitled to receive additional compensation, bonuses, or incentives from the listing brokerage firm, the seller, or any other source unless agreed to by buyer in writing. So we might, as we review this contract, you might say, hey, we have the resources to pay you separately. We think it might even give us an edge in writing an offer that the seller's not obligated to pay you, or not obligated to pay you, or we're not requesting them to pay you. So we're just going to pay you and leave the seller and their brokerage firm out of that compensation. And let's move forward and write a contract. So that's what 7.3.2 would be. So either we're going to ask the seller to pay me some compensation, and whatever, if they're willing to pay me, that's great. And if there's any discrepancy or difference, you would make up the difference. Again, that's negotiable. Or you're just going to pay me, and we're not even going to ask the seller or request them to pay me any compensation. So that's the new way of doing real estate here moving forward for compensation. 7.4 talks about a holdover period. And this is where I would be eligible for a success fee if for some reason my services to you terminated, the contract period ran out, and you decided you wanted to work with somebody else. If you go under contract and close on a property on which I negotiated on your behalf prior to our listing period ending, then I would potentially be eligible for a success fee. So that's something we can talk about if we're going to be working together, and I can explain it more thoroughly. But that's essentially what it's talking about for a holdover period, and how long it will be, and whether or not you're obligated to pay for a success fee to me. And then 8 is pretty straightforward. I'll let you read that. Section 9 talks about the buyer's obligations to broker. And so entering into this contract, we need to have things clear that you are not working with somebody else, and I'm exclusively working for you, because that just avoids stepping on other people's toes, potentially sign crossing, and there's legal implications to that. So we don't want to interfere with any existing professional relationships that you may have. So make sure that you don't have one, and that you're working solely with me, and as we move forward. So, but I'll read it to you. It says, buyer agrees to conduct all negotiations for the property only through the broker, and to refer to broker all communications received in any form from brokers, prospective sellers, or any other source during the term of this buyer listing contract. I should point out here that, if you're out in the community and you're talking to somebody and you say, oh yeah, we're looking to buy a house, and somebody says, oh, I have a house to sell, or my neighbor is selling their house, I think it would be perfect for you. Whatever the case may be, you take that information, get their contact information, let me know, and then I'll reach out and take it from there. So this contract means that you're going to let me handle all the negotiations and communications related to the property. And then it goes on to say that buyer represents that buyer is or is not currently a party to any agreement with any other broker to represent or assist buyer in the location or purchase or lease of property. So this is where we'd want to check the box is not. We don't want to interfere with those existing professional relationships. And then it goes on to say, buyer further represents that buyer has or has not received a list of any submitted property pursuant to a previous listing agreement to purchase or lease property with any other broker. So we want to make sure you're free and clear to work with me, and it's not going to cause any potential issues with a holdover period with another agent that you've worked with. Then we scroll down to section 10. This is where we talk about that formal legal term default and right to cancel. So if any obligation is not performed timely as provided in this contract, the non-defaulting party has the following remedies. So if I'm in default, you have the right to terminate this contract. And if you're in default, I have the right to terminate this contract as well. Section 11 talks about cost of services or products obtained from outside sources. So it says broker will not obtain or order products or services from outside sources unless buyer has agreed to pay for them promptly when due. And it gives some examples: surveys, radon tests, soil tests, title reports, and so on. Neither broker nor brokerage firm is obligated to advance funds for the buyer. So this is a conversation we have at the outset to make sure that you have sufficient funds for earnest money, for an inspection, and for any other aspects of purchasing a home that would not be included in your closing costs. We want to make sure that you have cash in hand so that you can write those checks and pay the appropriate services that you've requested. Buyer must reimburse brokerage firm for payments made by brokerage firm for such products or services authorized by buyer. So if we've agreed that I'm paying for something up front, then you must reimburse me timely for those services provided. Section 12 talks about my services to you as your broker. And so 12.1 talks about the following additional tasks will be performed by broker. Typically, I put none in that space because I provide the same services to all my clients. But if there's something specific that you want me to do, we could put that there. And it might be researching for sale by owner homes on Zillow or something like that. 12.2 talks about showing properties. It says buyer acknowledges that broker has explained the possible methods used by listing brokers and sellers to show properties and the limitations, if any, on buyer and broker being able to access properties due to such methods. Broker's limitations on accessing properties are as follows, and I have some boilerplate language that I put in here. It says those that are ordinary and customary, in addition to any special limitation placed on showing by the owner or listing broker of the property. A limitation, an example of that would be if you are interested in a home and it is being rented out and there's tenants living there and they work from home, and so they don't want anybody coming to the house except for between the hours of 3 and 5 p.m. on weekdays and 12 to 4 on weekends. So that would be an example of a limitation that we might come across. And then broker, through brokerage firm, has access to the following multiple listing services and property information services. Typically, I subscribe to the IRIS MLS that covers all of Northern Colorado. We do have agreements with RE Colorado. So if there's any listings that are up this way but are not listed on IRIS, but they are on RE Colorado, I would also get that listing information as well. And currently, as of the making of this video, there is a cooperative agreement where they're sharing listing information. Section 13, disclosure of buyer's identity. I typically check the box does, but again, that's a conversation we can have. You might not want me to disclose your name or anything like that. But I say does have buyer's permission to disclose buyer's identity to third parties without prior written consent of buyer. For example, if we're under contract and you want to get an inspection done and the inspector says, hey, what's the buyer's contact information so I can reach out to them and get the inspection scheduled? That would be an example of, if we check the box for does, I already have the permission to give them your contact information so we can get that ball moving forward. Same thing with the title company. They might ask for your contact info and I'll say, yeah, sure. And I'll shoot them an email with your email address so that they can send you title documents, what have you. Section 14 talks about disclosure of settlement service costs. That buyer acknowledges that cost, quality, and extent of service vary between different settlement service providers, such as attorneys, lenders, inspectors, and title companies. I have a list of these various professionals that I would send to you that you can do some research on, see how much they cost, and see which one's going to be the best fit for you. So we leave that on you, but do know that there is difference in level of services and costs and those kinds of things related to those professionals. And then 15 is a straightforward disclosure about wire fraud. It does happen, and so we want to make sure that if you're wiring any funds, that you contact the title company that we're working with, and they will give you specific instructions on how to wire funds. There are warnings that some people will try to hack into my email or something else or someone else's and make it look like a very professional email and say, hey, we've had a change, call this number to get wiring instructions. Ignore those. Let me know if that happens because we want to make sure we protect your assets. I should let you know that with my email that I have specific protections in place such that that would not happen. But again, pay attention to those emails. And if you have any question about it, err on the side of caution and let me know, and we can see if that email is legitimate or not. 16 talks about removal of marketing material, and it states buyer acknowledges that marketing material used by the seller and the seller's broker may be difficult, if not impossible, to remove from syndicators and the internet, and releases broker from any liability for broker's inability to remove the information. So you buy a house, you get to closing, you get the keys, you move into your house. Photos of the home that you live in are still on the internet. So anybody can look up that listing and see what the inside of your home looks like. So we tried to remove that marketing material, but it's impossible because once it gets syndicated out to realtor.com, Zillow.com, and all of these other sites, it's out there and it's nearly impossible to remove. So just know that when you buy a house, potentially somebody could look it up and see exactly the floor plan of your house and those kinds of things. All right, we scroll down to section 17, just a disclosure, we are not allowed to discriminate. So buyer understands and agrees that the broker may not violate federal, state, and or local fair housing laws. So pretty straightforward. Recommendation of legal and tax counsel. I explained that at the outset of this video. Buyer acknowledges that broker has advised that this document has important legal consequences and has recommended consultation with legal and tax or other counsel before signing this buyer listing contract. Mediation. If a dispute arises relating to this buyer listing contract, it's stipulated that we will first proceed in good faith to submit the matter to mediation. This is a good provision to put in here. I will say I act as a competent professional with integrity. If I do something wrong, I will take care of it. I'll let you know. But should it get to mediation, this is good because it protects you from having to hire an attorney to pursue me or the brokerage firm with a lawsuit. And so this is a cheaper way of doing it. And it helps us to come to terms that will serve best all interested parties. Attorney fees. In the event of any arbitration or litigation relating to this buyer listing contract, the arbitrator or court must award to the prevailing party all reasonable costs and expenses, including attorneys and legal fees. So if it does come to a lawsuit or litigation, the party that wins gets their fees paid for. Additional provisions, if there's something specific that you wanted to put into this contract relating to the services I provide for you, we would write that in here per your direction. There were any attachments we would attach to this. No other party or intended beneficiaries, nothing in this buyer listing contract is deemed to inure to the benefit of any person other than the buyer, broker, and brokerage firm. And then notice, delivery, and choice of law. This is how documentation and communication is legally delivered. You can read that there. Modification of this contract. This is good. It protects you and me. So no subsequent modification of any of the terms of this buyer listing contract is valid, binding upon the parties, or enforceable unless in writing and signed by the parties. So you can't add anything or take anything away, nor can I. It has to be agreed upon in writing and signed by both of us. And then the counterparts, it talks about that the buyer listing contract may be executed by each of the parties separately, and when so executed by all the parties, such copies taken together are deemed to be a full and complete contract between the parties. So an example of this would be, we are not together in my office, but you're in another state and I'm here in Colorado. We come to terms, we agree on everything, and then I send it to you via electronic signature and you sign it from some faraway location. When all the required parties sign it, it becomes an active contract, and it's deemed to be a full and complete contract between the parties. And then it goes on to say the entire agreement. This agreement constitutes the entire contract between the parties, and any prior agreements, whether oral or written, have been merged and integrated into this buyer listing contract. So whatever you want to have in this contract, this depicts the entire agreement of everything that we've discussed and the terms that we've all agreed on. And then of course, 28, you'll get a copy of this contract. And 29 is Megan's Law. This is important. If the presence of a registered sex offender is a matter of concern to buyer understands that buyer must contact local law enforcement officials regarding obtaining such information. So I can't provide that information to you. The good news is that local law enforcement, whether local municipalities or sheriff's departments, or there's a federal database too that talks about the existence of registered sex offenders in a community. If that's a concern for you, you need to look that information up on the appropriate websites. I can point you in the right direction, but that is some due diligence that you need to do on your own part. And then This last sentence here, the brokerage firm authorizes me as the broker to execute this buyer listing contract on behalf of the brokerage firm. So that is the exclusive right to buy listing contract. We would both sign here, you under buyer and me under brokerage firm, and that would make this a mutually executed contract, and we would be moving forward working together to help you buy a home. So hopefully this was helpful. I know going over contracts and documents isn't the most fun thing, so if you made it to the end here, greatly appreciate you hanging in there. If you have any questions, don't hesitate to get in touch. You can reach me at 970-313-6706, or my email address is there as well as my office address. And I look forward to talking to you soon. Take care.